All right, the big talk. First off, into the details of the big talk, let's talk about why I am here and why am I talking to you about this? Well, I'm an attorney and counselor at law, and I'm also a licensed real estate broker. A lot of what I do is helping families get ready for the time when the elder members of their families need help doing stuff. And that's, not only legal, but then we'll get into that in a minute. I've been practicing for a while. My office is on Robinson Street in Orlando. Been in the area for a long time. But I didn't really take a huge interest in elder law until I needed to start helping my parents. I was doing other stuff for a long time, small business and bankruptcy and Social Security disability, and I'm appointed by judges as an attorney ad litem. But I never really got into the elder law thing because I didn't really know about it, and it never touched me at all. Well, at the point where about 10 years ago, when both of my parents went from terrific health and really sharp to poor health and dementia, things started happening quickly. And being the son who lived closest to mom and dad, guess who did the running around? Okay, everyone else is scattered all over the place. We got Tampa, we got Washington State, we're all over the place. And so it was a challenge, and I learned a lot. And so part of what we're going to be talking about today is what are some of the things that you need to have a discussion with the family. And it's not only children having the discussion with the parents. Often I find parents wanting to talk about this stuff with their adult children, and the adult children are just kind of like, I don't want to talk about that. So it's getting everybody together on the same frequency, because you know what? Some things are unavoidable, and it's better to be ready. All right, so that's what we're going to be talking about here. So now, the big talk. You remember the first big talk that you had? Okay, this is when mom and dad sat down with son or daughter and talked about the birds and the bees, the things that you needed to know when you went into adulthood. Okay, well, now the tide has changed. Things are switching around. It is now usually the adult children who have to have the talk with mom and dad. And so this is the scene that we often see. And why is that even necessary? Well, it used to be that as a member of the family got older, what would they do? They'd move in with son or daughter. Everyone lived in a small town. There was lots of relatives around. So caring for people was not really an issue, because all you had to do was jump on the phone and talk to Aunt May, and she would come over and take care of mom while you were at the bank or something like that. Well, that's changed now. Also, the fact that the people are living so much longer. It used to be, back in your parents' time or your grandparents' time, when someone got sick, they didn't last long. Okay? Well, these days, people are lasting a lot longer. In fact, the amount of time that people are spending in assisted living facilities and nursing homes is climbing every year. So at some point, you have to sit down and talk to people. So what are we talking about? Well, the list of things is, how are you doing? How are you feeling? Where are you going? Where do you want to go? Where do you want to live? How do you want to be cared for? Who do you want to care for you? Do you have your documents in order? And what documents are you talking about? Well, seeing that I only have 30 minutes, we could spend all day on this. We could do a whole day, breakout sessions and everything. But I'm going to talk about, from the legal perspective, the documents. Okay, there's a general rule that says you can legally sign documents until you can't. What does that mean? Well, there comes a point where people lose the ability to communicate effectively. Okay, the easy case was my dad. When his Alzheimer's was advanced, he didn't know what time of day it was, he didn't know what TV station he was watching, he didn't know what food was in the fridge. There was no way he could have signed a legal document. But when did that happen? Well, he was diagnosed with Alzheimer's 7 years before he died. At some point between that date and the day that he passed away, he lost the ability to sign legal documents. And for that reason, what I usually tell people is if you got the diagnosis of any kind of dementia, get your documents in order right now. You may not need them now, but there's going to come a point where you do need them, and the question is, will you be able to legally sign them? I mean, normally when people look at legal documents, this is what they see. I mean, it's gibberish, it's gobbledygook. I went to a language school to be able to translate it. It was called law school. I speak 3 languages, English, Spanish, and legal. And no matter what frame of mind you are in, if you're coming in to talk about a legal document in my office, guess what? I'm going to be doing some translating, even if you don't have dementia, okay? So the question here is, at what point does someone become legally incompetent? Well, for one thing, let's see here. Okay. If you look in the law books, it's pretty complicated. Okay, a person is deemed to be incompetent when they no longer display the ability to make decisions that are in their best interests, are unable to understand legal proceedings and transactions, or lack the mental capacity to understand the consequences of their actions. Well, how the heck do you know that? I mean, most people don't have the legal credentials to be able, or even the medical credentials, to determine for sure if a person is incompetent. And the important thing is that once they are incompetent, they lose the ability to sign legal documents. We'll get back to that in a minute. So what's the rule of thumb? My rule of thumb is, and this has so far worked in every instance, is when a person is no longer able to effectively communicate. So if you have a document that you're presenting to someone and you're trying to explain to them what it is and why it's a good idea, if they're not engaging in the conversation, when I tried to have this talk with my dad, he wanted to know where his car was because I had taken his car away because he went to Costco at 1 a.m. I don't know why, but he had an appointment. And so he was not engaged. I did not have the ability to communicate to him what it was I was talking about. And it doesn't have, and he could speak okay, but sometimes it is an instance of being able to hear and speak. So the rule of thumb that anyone can get into, and you don't have to be an attorney to do it, is if a person has lost the ability to communicate what you're talking about with the documents, they at that point become incompetent legally. Okay. And the reason this is important is that there are only 3 people who can sign legal documents. The person, someone with an appropriate power of attorney, and a judge. So if the person can't sign because they can't effectively communicate, and no one has a power of attorney, then you got to go to a judge. You have to file a guardianship, which is a pain in the legal butt. I don't do guardianships because they are very difficult to do and they are expensive. And they are so preventable. If you have a good durable power of attorney, you probably will never need to file a guardianship with the court. And that's thousands and thousands of dollars and kind of difficult. And so how do you start the conversation? This was my dad's attitude when I tried to start the conversation with him. All right, he wasn't really interested because everything was fine as far as he was concerned. A lot of times people don't want to have this conversation because they feel like they're giving up some control. And with my dad, that was the big thing, because as his Alzheimer's got worse and worse, he realized that there was less and less that he could do, but except to say no. He could exert control over every situation by saying no. You ask him a question, no. Well, he won, okay? But that didn't help me when I was trying to figure out, help him with all of the documents. Also, a lot of times people don't like to acknowledge that there is even the necessity to do this. Okay, but it is very important. So, when you're having the conversation, sitting down with them to have the big talk, here's what you got to think about in starting it. Who's going to be there? When are you going to have it? Where are you going to have it? And how? So first off, who? Even though this is a family deal, some members of the family might not be someone you want to invite to this initial conversation. You know who you're talking about in your family, right? Everyone's got a member of the family who even though they may have the best of intentions, can screw up a conversation very quickly. So you have to choose carefully who you have this with. It's not like you're hiding someone for something, from anything, but you definitely want to make sure that you have the ability to communicate with your family member who needs to sign these documents, right? Okay, so when? That's kind of tricky too. You know your family member, and you have to figure out when it is that this is going to be best spoken about. A lot of times, people will choose around the holidays, where family is around, and you sit and you chat and you talk about it, and that works pretty well. And where do you have it? It's best to have it at home, in a location that's comfortable. I never suggest people come into my office with their parents and have the talk in my conference room. I mean, people don't like to go to law offices in any circumstances, and so no, this is a kind of a life-changing thing, and they really need to do it in a comfortable situation. Okay, so where do you start? How do you start that conversation? I usually encourage people to start by talking about what happened to family members. Okay, remember when Aunt Jane needed a guardianship after she got dementia and it cost so much money to the family? That was a terrible situation. I don't want that to happen to you. Okay, so there are always examples of things that you can bring up to kind of bring it in. Another thing is that in talking about these papers, I say, Mom, I know you don't like to leave the house, but sometimes I need to go out and do stuff for you. So if you sign this document, this allows me to go do at the bank what you want me to do. With my dad, I told him, he's the general and I'm the foot soldier. He sits at home, he can tell me what to do, and I got to go do it because we got this document. He liked that because he was in control. Okay. And also, you can blame the lawyer. You can say, well, I heard this lawyer that said this is really, really important to do, and people end up spending a lot of money if they don't have all these documents. So we really ought to do it, because ultimately, you want the family to remain in control over the situation. If you don't have the right documents, you have to go to court, and you have to have a judge make the decisions, and this will be a judge who has never met any of you before. And talk about, dragging your family member into court when they need the guardianship. And even if you've never been involved with a guardianship, one of the first things they do is an examination by a doctor to find out if a person is competent. And that's very uncomfortable. Even the nicest doctor, it's just an uncomfortable situation. So what are the documents that we need? Some of the basic ones. I'm going to go through them. And the most important one, I believe, is durable power of attorney, and also general power of attorney. Designation of healthcare surrogate. healthcare directives, which in some places they call a living will, and finally, and usually less important, believe it or not, is the last will and testament. So let's go through them. A durable power of attorney. Now everyone knows what a power of attorney is. If you're going to be out of town, you sign a document to let someone else go and do business for you if you need to do it. Okay? And what most people don't know is that regular power of attorney only is no good after a person loses the ability to sign legal documents. After they become legally incapacitated, a regular power of attorney no longer works. What you need is a durable power of attorney. That's what this is right here. It is a power of attorney that works all the way until a person passes away. And so this is why if you have one of these, you don't ever need a guardianship, or extremely rarely. But this will save a lot of difficulty. This is also important because there will come a time when the family member isn't even going to be able to make the decision as to whether or not they go into an assisted living. My father wanted nothing to do with it. But at that point, the roles changed. It was like I had to take the role of the adult, and he had to live with the role of the child. It was uncomfortable, but it had to be done. And what allowed me to do it was the durable power of attorney. Because if I didn't have that, the assisted living facility would not deal with me. Because my father was not able to sign documents on his own. He couldn't sign the document saying that he was going to live there and that we were going to pay for it. But with the durable power of attorney, I was able to do that. And again, all falls back to the really important thing is that you don't know when you're going to need it. Just last month, my next door neighbor, Gene, well, let me put it this way. 2 months ago, Gene could sign legal documents. Last month, he could not. Being in apparently perfect health, he had a stroke. All right, and after that, he was not able to communicate very well. So he became incapacitated instantly, right away. And if there were documents that he needed to be signed, it was too late, too bad, because there's nothing you can do. So as a preventative measure, everyone ought to have a durable power of attorney. It's like one of the most important things that you can have. The other important item, and all your doctors and hospitals are going to ask about this, do you have a designation of healthcare surrogate? So what is that? Well, it's kind of a power of attorney for health care. And what it does is that if a person, if you have one of these, and say you leave your son or your spouse or your son or your daughter as the agent, as the surrogate, and you can't communicate with your doctor. The doctor says, here's the procedure that I want to do, and you can't say yes or no because you're not unable to communicate, then the surrogate comes into it. And the doctor has to consult with family before doing anything. The designation of healthcare surrogate is another way of keeping the family in control over the situation. And another thing about this is the family has whoever the healthcare surrogate is, they have the ability to go and look at all the medical records. Under HIPAA, which is the Healthcare Records Act, someone with this kind of authority has the right to say, I want to see all these records, give me a copy of everything, I'm going for a second opinion. If you don't have one of these, you can't do it unless you go to court and get a guardianship. It's like all the stuff, if you don't have it, you got to go to court. You got to deal with lawyers, and they're expensive. And judges are so judgmental. They're just like, some of them are nice guys, but no, it'd be best not to have to mess with them. This is another important one. Now, an advanced health care directive, this is a kind of confusing one because in some places they call them living wills, personal directive, advanced directive, medical directive, or advanced decision. What this is not a will, okay? They really should never have called it that. This is a document that says, If I am to the point where I am not going to survive, I don't want to be artificially maintained. And you can have this thing say anything you want. You can say, I want to be kept comfortable. You can say, I don't want them to withhold medications. I don't want them to withhold food or water. I mean, you can make this as detailed as you want, but this document basically says, in the end stages of life, how you want to be treated. Okay? And then a regular last will and testament. Some people will tell you that this is what you got to have. But a will, a last will and testament, is just a letter to a judge saying, Judge, I'm not here, do this for me. Okay? And then the probate judge, who's in charge of this, will do that. They'll appoint some member of the family or a friend to take care of business on your behalf. But you know what? The only time you ever need a last will and testament is if you have property that's in your name only. Okay, so if the house is in joint names with your spouse, or the house is set up so that it's like with a ladybird deed and it's going to go to family members, and if your bank account has beneficiaries, and if your insurance account policy has beneficiaries, and there isn't going to be anything in your name only at the time you pass away, you'll never see the will will never come out of the drawer. And actually that's okay, because that means you've done a good job of planning things so that the family doesn't have to do all this expensive stuff at the end. So as part of why I am here today, and we're going to open this up for questions and answers, and I'll stay until they kick me out. We only have an hour, and at a certain period of time, the nice young lady in the back is going to hold up signs. 15 minutes, 10 minutes. But anyway, so we'll be fine. Here's something that I offer. It's called the Elder Law Document Portfolio. And if you passed my booth 606, I had a great big banner there, and my lovely assistant is going to be handing out a copy of the flyers. And what it is this is a package of documents that I have, these basic documents that I was talking about. And I work with a lot of organizations. I do a lot of in-service for healthcare providers. I go and talk to a lot of groups. And it includes the durable power of attorney, which I call it a Florida durable power of attorney, but it's really good anywhere. It's a multi-state one. I throw in a general power of attorney, just because it's a little bit easier for some stuff. Designation of healthcare surrogate, the medical power of attorney that we were talking about. And if the person wants, I do the advance directives, the living will. And then I will do a last will and testament as a kind of a catch-all, just in case. Because, for example, if at the time you pass away, you have a paid-off car that's worth $20,000, well, it would be good that, you can handle that. So, a lot of firms will charge an awful lot of money for these things, at least $1,000 a person to do it. To encourage people to do it, what I charge for the portfolio is $275 a person and $450 for a couple. Okay. My hourly rate is between $250 and $350, but I don't charge that. I do flat fee. I guarantee I'm putting in a lot of time on these things, but they're important. And I give free consultations. And one of the reasons I do this is because I'm also, for example, I do other areas of law too, and I'm also a real estate broker. So if you come in and I give you good service and you like me, maybe you'll come back. And I think that's a cool way of doing it. So anyway, in my building on 2110 East Robinson Street, and I'm going to be passing out something with my address on it. We have my firm, Eric L. Bulbus, Esquire. I do have Burgos and Bryan. They are wealth managers. And one of the things that they do is really kind of an amazing thing that they introduced my father to. It's called the Aid and Attendance Pension. I never knew existed. My dad was a vet during a time of conflict. Okay, he was only in the military for 2 years, but he was in during a time of conflict. And because of that, when he needed help around the house, there was this there was this additional benefit through the VA called aid in attendance that this year pays $1,800 a month, tax-free. Pretty amazing. So if you want more information about that, stop over to the booth. I'll introduce you to Matt Carley over there, who works with Burgos and Bryan. Additionally, I am a real estate broker with International Drive Real Estate. I'm the managing broker here. And, in fact, Matt just walked in the back door, so you can mug that guy about the aid and attendance when we're over. Okay, so now at this point, I am going to open it up for questions, and so we can get it recorded. I have a microphone here. Sharda, can you come up? And does anyone have any questions on any of this stuff? Okay, so I don't see any hands, which means I either did a really good job or you're sleeping. But you're welcome to wander up here and ask me questions anyway.